Just a moment. It was really a rhetorical question.
Okay.
Because it doesn't make sense.
Well, it doesn't.
It doesn't make sense that you would stop talking. Then you really didn't qualify for court-appointed attorney services, did you?
I will figure it out.
This is what you're not going to do. You're not going to talk while I'm talking.
Okay.
I said that when you were before me earlier, but you still seem to think you can talk while I'm talking. Ms. Wall?
He said I needed to say it to
Ms.
him.
Wall, you have to stop talking. That's the way it works. Once more, in my courtroom, you'll be banned. I just wanted to tell you, you are not welcome back. Don't come back to my courtroom. That's it.
All right, now you can leave.
This defendant chose the very morning of her jury trial to dismiss her lawyer, claiming they never really spoke. That claim is one of the most common ways people try to delay a criminal case at the last minute. Courts see this tactic often, especially when a trial is about to begin. What makes this situation more serious is the type of charges she's facing. These are felony drug charges related to meth possession, which can carry significant consequences. Even so, she's acting as if the courtroom works like a customer service desk where you can simply request a new representative whenever you feel like it. Things get even more tense when her mother jumps in from the gallery, speaking up as if she's part of the hearing. That's something judges rarely tolerate because courtroom procedure requires everyone to follow strict rules about who can speak. And this judge makes it clear very quickly that the interruptions and last-minute demands are not going to change how the court operates. With that context in mind, let's take a look at how the moment unfolds.
Good morning, Your Honor. Candace Mann on behalf of the people, P80652.
And good morning, Your Honor. Danian Woodson, P68870, on behalf of Ms. Pruitt, who is standing to my left. Ms. Pruitt, please state your name for the record.
Jessica Pruitt.
Good morning, Ms. Mann, Ms. Breton, and Ms. Pruitt. An issue as to whether the parties want to settle this matter. And we have a jury that is waiting. I understand after having a sidebar discussion with counsel, Ms. Pruitt, that you want to proceed to trial, but you want a new lawyer. Is that right?
That's correct. We have not spoken one time one-on-one about this case. I don't feel like I've been represented at all. I've not been guided. I've been kind of doing it on my own. It's great. I like her and everything, but I need somebody who's going to see what I'm talking about,
Did she review the discovery with you?
She sent it to me in an email. We've never spoke about anything.
You didn't discuss it with her today?
No.
You didn't discuss the offer today?
No, not the offer again. The last offer that she told me, I said no to.
So you're saying that you have not spoken about the case with your attorney this morning?
No, at all, period. Throughout this whole process. I've wrote emails stating my concerns and she's emailed me back, but we've never got to discuss the actual, event of what led up to this.
Well, we've had 1, 2, 3 final conferences. And
That's
you are
correct.
telling me now, after 7 hearings, that you had not spoken to your attorney? Is that
correct.
Right?
Yes, that is
Does
correct.
that make sense to you, Ms. Pruitt?
Well, I gave the benefit of the doubt. I was
It's
hoping
actually-
that she would surprise me.
No, just a moment.
I don't know.
Just a moment. Just a moment. It was really a rhetorical question.
Okay.
Because it doesn't make sense.
Well, it doesn't.
It doesn't make sense that you would stop talking. It doesn't make sense that you would not have advised the court that you hadn't spoken to your lawyer in 7 hearings.
Right.
Now, what she did or didn't do is a different issue, but I have to find strict necessity to avoid manifest injustice to adjourn or reschedule a jury trial on the day of trial when all of the preparation for your trial is made before today, and there's a jury that is at this moment waiting for me to call them from downstairs. So do you intend to hire an attorney?
I do.
Okay, how long will it take you to do that?
I'm not sure. It won't find one today.
So how long do you think it would take you to engage an attorney?
Maybe a week or so.
I can't have a maybe. You know what your finances look like.
Okay.
How long will it take you?
A week.
If it would take you a week to get an attorney, then you really didn't qualify for court-appointed attorney services, did you?
Well, yes, I did. I will figure it out. I mean, there are ways to get. There are ways. to make
Ms.
it possible.
Pruitt, your case needs to be tried or your case needs to be settled. Either way, you need to have an attorney.
I understand.
And I don't want to set a date for no reason. I need you, and this is my third time asking you now, to give me a date where you can be confident that you can have an attorney of your choice whom you pay for standing beside you. How long will it take you to do that?
A week.
Okay, so we'll come back in a week. We'll schedule the jury trial at that time when you have a new lawyer. And just so you know, Ms. Woodson, I'm going to be looking into the allegations that Ms. Pruitt made today. They're very serious, and I cannot let them go unaddressed, especially because it appears that it is requiring the delay of jury trial. 9 a.m. Make sure that you tell your new attorney, Ms. Pruitt, of the date.
Okay, thank you.
Good morning again, counsel. And Ms. Pruitt, please state your name again for the record, ma'am.
Jessica Pruitt.
Thank you. Thank you for coming back so quickly, Ms. Pruitt. When you left, I had another sidebar discussion with counsel, and I realized, while I was made aware, that I did not give Ms. Wooden an opportunity to respond to your allegations. So I'm going to do that now. Ms. Wooden?
Yes, Your Honor. The court instructed me at sidebar earlier today to call to find out exactly where Ms. Pruitt was, how far away she was, and if she was interested in the offer. At which point I stepped out into the hallway into the conference room and I called Ms. Pruitt, asked her how far away she was. She said she was on Grand River. I said, Grand River what? She said she was 8 minutes away.
Things suddenly became much more serious here. The judge actually called everyone back into the courtroom after realizing she hadn't given the defense attorney a chance to respond. That decision completely changed the tone of the moment. Once the lawyer began speaking, she laid everything out clearly. She explained that she had spoken with the defendant on the phone only about 10 minutes earlier. Then she started listing specific dates, times, and conversations they had previously. It was like watching a detailed record being read line by line. That information directly challenged the earlier claim that they had never communicated. Instead, it showed that there had been contact and discussion about the case. The timeline the attorney presented made it clear that communication had taken place. It's a strong reminder that statements made in court can be verified very quickly. When someone makes a claim in front of a judge, the other side often has documentation ready to support their version of events. In this moment, the record spoke for itself and changed how the situation looked almost immediately.
And I asked her about the offer again. We discussed it. I explained to her that even if the narcotics were found to be not hers, she's charged with 2 felonies. And based on her behavior in the body cam footage, the resisting and obstruction charge was likely to happen. I also explained to her, when the officers told you to stop, you were supposed to stop. When you don't do that, that is failure to obey a lawful order. When you continue to thrash around, that's resisting. We had that discussion this morning. She said she wanted an attorney who believed in her, at which point I asked her if she wanted a new attorney, and she said yes. At that point, I went out in the hallway. I looked for the prosecutor. I explained to the prosecutor what happened. Shortly after that, Ms. Pruitt came into the courtroom. We asked for approach, and there we are.
So
I'll admit that Ms. Pruitt has changed her phone number. I just got an email from her this morning with the new phone number, and that's the phone number I used to call her when the court instructed me to call her. We have communicated primarily through email because the phone numbers that I have from Ms. Pruitt keep changing. We were supposed to discuss this case on Monday at 2:30. The phone number I had for her then, I didn't receive an answer. That's the same phone number I texted her at this morning at 7:45 to tell her we were in Judge Green's courtroom. At 9 o'clock, I decided to email her to ask her if she received my text. She said no. She thought the court date was at 10. That's when I reminded her. I told her 8:30. That's when she told me about childcare stuff in the email, and that's when she emailed me her new number to say that I can't remember, she said she lost her phone and her phone was broken.
okay, so her allegation that she's never spoken to you about the case is technically accurate, but you've had communication with her via email is what you're saying.
Because of the lack of phone communication, because of the inconsistencies of the phone numbers, I have spoken to her before and after every court date. I have also worked with the prosecutor to try to make this offer as favorable as possible for her. We had agreed to not only dismiss the resisting obstruction, but to allow her to plead to 7-4-11 on the possession charge and to do it as a no contest plea.
What's the offer, Ms. Mann?
Your Honor, the offer is for the defendant to plead to a reduced charge of count 1. It would be reduced from controlled substance possession of methamphetamine to attempt possession of methamphetamine, which reduces it from a 10-year felony to a 5-year felony. In exchange, the people are agreeing to dismiss count 2, police officer assaulting, resisting, obstructing with a sentence agreement of 2 years probation, substance abuse evaluation and treatment as directed, anger management, 40 hours of community service. The defendant is eligible for a sentence under 333.7411, and the people would have no objection. And then any other terms or conditions or fines that would be set by the court.
After hearing from your lawyer, who's an officer of the court, by the way, so I don't need to put her under oath. Anything that she tells me is the equivalent of being under oath because of her status as an attorney. This is what you're not going to do. You're not going to talk while I'm talking.
She simply can't stop interrupting the judge, and that's making the situation worse for her. During the hearing, the judge had to step in and firmly tell her that she needs to work on controlling her reactions and listening before speaking. Moments like that show how important courtroom behavior is, especially when the stakes are high. What makes it more surprising is that she's facing a serious felony charge that could carry a sentence of up to 10 years. In a moment like that, most people would stay quiet and listen carefully to what the court is saying. Instead, she keeps talking over the magistrate while the judge is trying to explain what appears to be a fairly generous plea option. Rather than recognizing that the court may be offering a chance to resolve the case with less severe consequences, she seems more focused on arguing and reacting emotionally. That approach rarely helps in a courtroom, where patience and respect for procedure matter a lot. The judge actually shows a great deal of restraint by continuing the explanation instead of immediately taking stronger action, such as revoking bond. Situations like this raise an interesting question. Is the defendant simply overwhelmed and nervous, or is she struggling to slow down and listen to what's being said?
I said that when you were before me earlier, but you still seem to think you can talk while I'm talking.
I'm sorry.
It's hard because you need anger and impulse control management. That's why. Control yourself.
Okay.
This offer is exceedingly generous, especially the 7411 component. And although I have never done it, if you go to trial on this and you are convicted, I will be sentencing you with the fact that you had no defense in mind. Do you understand? Okay.
Thank you, Your Honor.
Thank you, Your Honor.
Your Honor, would the court entertain a motion to withdraw?
No, no, because she doesn't have a lawyer right now. But I will at the next hearing.
Okay.
Ma'am? Call her back here. Ma'am,
And you can stand right up here.
Right here.
Yep.
who are you?
I am Jessica's mother.
And your last name be Pruitt or something else? What's your
Something
name?
else.
What is it?
Walls, Walls.
Thank you. Ms. Walls,
Yes, ma'am.
you're welcome to be in this courtroom anytime that you are in the area, for that matter. This is a public space.
I'm aware.
I understand why your daughter interrupts people
I
while
knew
we're
you were
talking.
going to say that. Yeah.
Yeah,
Go ahead. I'm sorry.
you can't help it, can you?
I can't help defending myself when I feel like my rights are being violated. That's right. I simply was stating a fact that on the board downstairs, it does say 10 o'clock. I didn't take a picture of it,
Miss-
but I just wanted to make you aware of that.
Ms. Wall?
He said I
Ms.
needed
Wall,
to say it to
Ms.
him.
Wall, you have to stop talking. That's the way it works.
I see.
I would like for you to be welcome in this courtroom anytime your daughter is here before court. If you are disruptive once more in my courtroom, you'll be banned. That's why I brought you back, to tell you that. Do you understand?
I understand.
Thank you.
All right.
Am I able to speak now?
I would
No.
like to. To help.
We're stating the truth.
Ms. Wall? Ms. Wall?
So you really want to entertain my motion, Your Honor?
No, I will not. The apple certainly doesn't fall far from the tree. I just wanted to tell you, you are not welcome back. Don't come back to my courtroom. That's it.
All right, now you can leave.
Have a good life.
I advise you not to say anything on the way.
And you're welcome to view on YouTube anytime your daughter has a hearing.
That hearing was honestly tiring just to watch, so you can only imagine how challenging it must have been for the judge. The situation turned into a difficult mix of interruptions and tension. The daughter was claiming her lawyer hadn't communicated with her in an attempt to delay the trial, while her mother repeatedly tried to speak from the gallery as if she were part of the case. Moments like that show how important accountability and courtroom decorum are. Instead of helping the situation, the interruptions and accusations only made the atmosphere more strained. Through all of it, the judge remained calm and professional, which takes a great deal of patience in a setting like that. It also highlights something many courts emphasize. When someone is facing serious charges, the best approach is to listen carefully, stay respectful, and work through the legal process properly. Reacting emotionally or arguing with the court rarely leads to better outcomes. Unfortunately, the mother's involvement may have made the situation appear even more difficult from the court's perspective. Now the daughter is expected to return next week for the next stage of the case, and she'll have to face those proceedings on her own. What do you think will happen when she comes back to court? Share your thoughts in the comments. And if you found this case interesting, don't forget to like the video and subscribe for more breakdowns like this. Thanks for watching, and take care.